my friends. And thank you so much for coming to spend your lunch hour with me on this Tuesday, April 9th of 2024. It is 1 p.m. here in New York. And do you know where your children are? How is everyone today? There's supposed to be a hearing on Karen Read at 2 p.m. Eastern. I don't know if anyone is going to be broadcasting it. So if anyone knows for sure, if you can put it in the chat. I had too many tabs open, but I was watching the live court TV feed and they were broadcasting something else. I was also checking Law and Crime, Boston 25, but I can't keep all those tabs open, but we'll see. Oh, thanks. New intro. One of my kids made that. Shout out to Scarlett on Canva the other night. And I thought it was really cute. And we found some music to go with it. So I like it. I like it. And it gives me a little extra time to get ready back here. Not much, maybe 30 extra seconds, but everyone knows every extra second counts, right, my friends? So if anybody knows where this hearing is going to be, you think Fox 25 is going to have it, Dawn? All right, cool. I have it up, or I will have it up. And we will take a look at it. My understanding, somebody said in chat that the defense is not going to be there today. And I'm not surprised because I don't think that they need to oppose this motion. I don't think that they would have any opposition to this motion. But we will get to all of that. And we are going to talk about the order on the buffer zone because I just posted like a little synopsis of it on my community page because I think I had done a stream that day that the order dropped on that. And then we are going to take a look at the media protocol order that the court has issued with regard to the media coverage that is allowed to be during the that is allowed to happen during the trial. And then we're going to take a look at today's motion and see what they're asking for and why they're asking for it that the Boston Globe made. So it'll be interesting. It'll be a little catch up. And then if somebody's streaming it live, we'll cut live to the hearing at 2 p.m. So I'm so happy to have you all with me today. Opening day. Is it opening day for, what's it opening day for? For baseball? The link about we'll have it when it begins live. Cool, cool, cool. Yeah, Solomon Landscaping says, just like how I can't keep all the tabs on how many times the Constitution has been trampled on over the past few years. Yeah. And it's interesting because in this motion the Boston Globe makes, they talk about constitutional rights and First Amendment rights and freedom of the press, which if you've been following the Karen Read case with me or with anyone or even on your own, you can see that the First Amendment rights have already been trampled on, as has freedom of the press and the lack of the journalistic privilege that exists in Massachusetts. So learning a lot more about Massachusetts court rules than I ever thought I would. But as you know, I'm a New York attorney. So every day we learn something new. Oh, okay. We won't tell anybody. Don't tell anybody that it's opening day. You could have that on your other device. You could have me on your laptop. You could have the game on TV. And then, if anybody wants to post the score, that's cool. As long as we don't, redirect. So here's breaking news for those of you who haven't watched it yet. Jennifer and James Crumbley were just sentenced in a Michigan courtroom. Was anybody following that trial or those trials? If you don't know about the Crumbley case, they are the parents of a school. We have to say pew pew in the first 5 minutes in Michigan. And they were both just sentenced by the judge to 10 to 15 years in prison each. The victim impact statements were heart-wrenching. Many of the parents got up and spoke and gave statements, and at least one of the victim's sisters got up and spoke, and it was heart-wrenching. Both of the defendants, Jennifer and James Crumbley, spoke as well, expressing remorse, but also saying that they did not know the extent of what was going on at the school because the school did not tell them about a lot of things. And at one of the, I think it was Tate Mears' dad, got up and he said, I'm not even going to address the Crumbleys at all, but I want all of you to know that you have not even seen the truth yet. Did you see that, you guys? He went on for a couple of minutes about what the truth is and what the school knew and how the school shouldn't be getting off the hook here. So it was very interesting. I would imagine there's going to be more stuff breaking about what the school knew and didn't know. But each of the parents was sentenced to 10 to 15 years in prison. And I did cover Jennifer Crumbley's trial. I think I only did maybe 2 shows on it because it's very difficult. It's a very, very difficult case. It's not as vitriolic as the Karen Reed case with regard to people taking sides on that case, but there are so many issues at play in that case with regards to parenting, when the government can step in and sentence you to prison for something your child does. A lot of people have very, very strong feelings on either side, but know tonight that they are each going to be serving 10 to 15 years in a Michigan state prison, and that they are going to receive credit for time served. I think they've each served 2.5 years so far. And just so you know, the 2.5 years that they have spent in jail since being arrested has been solitary confinement for 23 hours a day, each of them. So while we look at our constitutional rights, and look, I'm from New York. This is not gun country here in New York. It's just not. I'm covering another case, a very tragic case out of the Oklahoma Panhandle, and that is it's an open carry state. So laws from jurisdiction vary. And in my opinion, the Crumbley case is a tragic case for everyone involved. And Ethan Crumbley will never see the light of day. He will be in jail for the rest of his life. But I don't know what 10 to 15 years will do for the parents. I don't know. I'm conflicted. You can tell me how you feel about it in the comments, in the chat. Yeah, you're right. C. Morales says James Crumbley threatened the prosecutor in a jail phone call. Yeah, that did come up. You're right. That did come up. So it's there's so many issues, like I said, at play here. What the parents knew, what they didn't know, what they should have done, what they didn't do, what they could have done, what the school knew, what the school didn't tell the parents. There's so many issues here, and it's hard. I got to tiptoe around it in my own head because I don't even know how to wrap my own head around it, really. Samantha says, I live in Central Oklahoma. I'm pro Second Amendment. And that's a lot of viewers feel that way. And that's what Dawn says too. It's not the guns, it's the people holding the guns. Yeah. I don't know. I mean, I don't know how I feel about that case. I think there was some misinformation out. So I do not know. Emmy says I'm conflicted too. They don't seem likely to reoffend, but my heart breaks for the victims' families. Absolutely. Absolutely. But keep in mind that the person who actually did the crime will be serving life in prison and never see the light of day. This is a case of first impression. It is the first time that parents of a school pew have ever been brought up on criminal charges in our country. And we say about a lot of things that a lot of things are slippery slopes, which is what we're going to talk about today with this buffer zone motion. It's a slippery slope because once they start taking some of your rights away, it becomes very easy for that to turn into taking more of your rights away because you agree with it the first time. And okay, at first it's a 200-foot buffer zone. Then it's going to be a 500-foot buffer zone. Then it's going to be nobody in the entire town of Dedham can wear a sweatshirt or a t-shirt. It keeps going and going and going. Yeah, and I see a lot of things in chat. He was a minor. They gave him access to the gun. There are some issues about, but it's okay for a minor to go to a shooting range in that state. So I think, and there's some conflicting information about whether it was locked up and whether the ammunition was in a different place. And there was a A lot of things that didn't come into evidence, like his journal and other stuff. And we talked about those other hearings, and some of us watched those other hearings that had to do with his mental capacity, and we, Ethan's anyway, and we will never unsee those things. But we can't get off on that tangent because today we're here to talk about Karen Read. So let's start there today, my friends, and then hold your questions maybe until a little bit later. And in the meantime, we're going to try and find out who's going to be streaming this live. Okay, so here is the order for the Commonwealth's buffer zone motion. Remember, the Commonwealth made this motion. We went over their motion. We watched the hearing on this motion. The people intervened, four interested parties intervened and had Mark Randazza, their attorney, file a motion to intervene, which the court did not address and said that we don't recognize a right to intervene in Massachusetts in criminal cases. The ACLU submitted a brief, an amicus curiae brief, which means friend of the court, to help the court decide. And the court said the court did read the ACLU's brief and was persuaded by many of the arguments that the ACLU of Massachusetts made. And here is the order that Judge Cannoni issued the same day as the hearing. And she said, we're not going to read the entire thing because we're just going to start catching up on a bunch of things before this hearing starts. While the court recognizes and appreciates the constitutional rights of the people to peacefully protest under the First Amendment to the United States Constitution, the defendant has the right to a fair trial by an impartial jury. You're going to notice, and I'm going to point out that several times during the course of this decision or order that Judge Cannoni makes, she talks about the defendant's right to a fair trial. And we need to remember that the defendant did not make this motion. The Commonwealth made this motion. So it seems to me that this isn't so much about the defendant's right to a fair trial because the defendant took no position on this motion. But it's more about, in my opinion, the Commonwealth's right to a fair trial, because if you've been outside the courthouse and you've been doing some peacefully protesting, you've been peacefully protesting. I do not think there are any people protesting on the Commonwealth side. If there are, please let me know. But I don't think that anybody has seen anybody protesting for the other side, which they absolutely 100% have the right to do. The court also recognizes that the defendant's right to a fair trial has also been characterized as a basic requirement of due process. And she goes on to say, to ensure the defendant's right to a fair trial, the court may restrict protected speech so long as the restrictions do not burden substantially more speech than is necessary to further, hold on, how do we switch this to the next page? Oh, really? Is it going to make me take this down and then put it back up again? Thought I had it all figured out. Okay. Now we go back, go to the second page. The way I had to do this was on JPEG because I couldn't get the full document. They have to balance that with the government's legitimate interests. She says, in this case, it's well documented that protesters have shouted at witnesses and confronted family members of the victims, which, by the way, I'm just going to say I think is horrifying. I think that is horrifying. I don't think that anybody should be booing or shouting at the Officer John O'Keefe's family members. I find that to be in incredibly poor taste. And perhaps that's one of the reasons that we're seeing this order come down in this way, because that's just not cool. And you can disagree with me on that, but I don't think that's cool. Thank you to Maureen Francis for your Cash App, and also to Justin. Thank you both so very much for your support, as always. She says individuals have also taken to displaying materials which may or may not be introduced into evidence during trial, airing their opinions as to the guilt or innocence of the defendant on their clothing or signage. I don't see anybody out there showing their guilt for the defendant. Has anybody seen anybody with signs saying that the defendant is guilty? Burn her at the stake or anything such as like that? Oh, is that what you're saying? Hold on. How did they get away with this situation? Is buffer zone? Hold on. That's not the one I meant to highlight. You guys are moving quickly in the chat. Jennifer says, I've seen the video where the people that they were with booed. And so people said they were being booed, but it wasn't them. It was the McAlvers. Okay. Not sure. And then people say no one was yelling at the family. Okay. Well, the court seems to think so. And the court is using that as reasoning for this decision. So that I find very interesting. Has anybody seen anybody wearing any Karen is guilty shirts or, burn her at the stake or 100% guilty or, cop killer or anything like that? Because I haven't seen it. Witness intimidation has also been a prevalent issue in this case. Given that these past actions, the court concludes that there is a substantial risk that the defendant's right to a fair trial will be jeopardized if prospective jurors are exposed to the protests and messages displayed on signs or otherwise, particularly before the court has had an opportunity to instruct the jurors about their obligations with regard to remaining fair and unbiased. Again, the courthouse has a back door. We know that. We know that the jury that was bussed in for the Chesna trial used the back door to come in and out of the courthouse. So we do know that that's an option, but she's not considering that option here. The risk extends during the trial where jurors and witnesses would have no choice but to be exposed daily to the messages and viewpoints of the protesters when entering and leaving the courthouse or sitting in the courtroom. Not if they come in the back door. There could be a buffer zone around the back entrance to the courthouse, but that seems like that's just too easy of a solution. Nobody asked me. The defendant here is entitled to a fair trial with an impartial jury free from outside influence, focused solely on the evidence presented in the courtroom during the trial and the applicable law. Again, the defendant here is entitled to a fair trial with an impartial jury. I mean, if you just substitute the word defendant with Commonwealth, I think you're really going to get an idea of where this is going. And am I biased? No, but I'm in favor of the Constitution. And I am in favor of the First Amendment and freedom of speech and the right to peacefully protest. So people in Massachusetts, please pay attention. This could have far-reaching implications, in my opinion. In my opinion, of course, as always, in my opinion. To protect this right, the court must reduce the risk of exposing witnesses or jurors in this case to such outside influences. Again, jurors don't have minds of their own, my friend. Not in Norfolk County, they don't, because they would be heavily influenced by anybody holding a sign, wearing a t-shirt, or even by their dog wearing a sweater with a saying on it. And here's the order. It is hereby ordered that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting, i.e., bullhorns or anything else that could amplify a voice. Doesn't want me to just be able to flip from page to page, so this is what we have to do, my friends. It is further ordered that no individuals will be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department-issued uniforms or any police emblems in the courthouse. So, tell me, what say you, my Massachusetts friends? First of all, a prohibition on law enforcement officers who are testifying or there to show support for either side against wearing their department-issued uniforms just really rubs me the wrong way. I think as an attorney, if I was trying a case and I know that a lot of detectives come in plain clothes, but I think if you have an officer testifying, I mean, I go to traffic court all the time, or I used to, or I sometimes go as favors for friends, and the state trooper or the officer always shows up in uniform in traffic court, always. Because an officer in uniform is going to have more credibility, theoretically, than an officer who shows up in plain clothes. I would also submit to you that perhaps they do not want people or police officers from Boston PD or any other law enforcement organization showing up to show support for the defense. I'd like to know what you guys think about this. I think uniforms show respect too. I think it also may be very confusing for jurors and members of the public and on television if there are so many different jurisdictions involved here and you have Massachusetts State Police showing up in one uniform, and then you have Canton PD showing up in other uniforms, and then you have so much confusion about all of the players involved in this case. And perhaps that is something the Commonwealth doesn't want. What do you think? Avea says, I'm not invested one way or the other. However, I would question the constitutional legality of this order. Yeah. Yeah, I mean, we did see this when we watched the West trial out of Bakersfield, California. That was Kern County, California, the trial for the boys, Classic and Sincere, whose lives were taken by Trezell and Jacqueline West, their adoptive / foster monsters who were convicted of their deaths, that nobody was allowed to wear t-shirts with the boys' faces on them in the courthouse or in the courtroom during the trial. And I could see this, but you know, 200 feet is pretty far. Jeanette says there haven't been any officers in court so far. Right. Uncle Fredo says they do not want to allow police in uniform because it will show how few of them believe Karen is guilty. Diane says, I can't wait for the defense to point out lack of support for the prosecution via law enforcement. P. Lola's mom says, so they're going to be asked, what uniform were you wearing at the time of the incident? And they have to explain. Waste of court time. That could be. That could be. I think there's a lot of the psychology, right, Eliza, the psychology of courtroom style. Buzzing for Truth says, wonder what they're afraid of. It's already a circus. Circus, kangaroo court. Helena says, how about firefighter uniforms? I think it says uniforms of any personnel. Valhalla Law, the order doesn't ban wearing t-shirts outside the courtroom, does it? No, but you have to be 200 feet away from the courthouse. So I don't know what's going on there in Massachusetts, but it frightens me. Let's see if this is a better way to do this. All right, here's the order regarding media coverage. So this is something the court did sua sponte. There was no motion before them to do this, to make this order. And this is just regarding media protocol and coverage during the trial. So she is requiring all media to register with the court pursuant to the court's guidelines on this. Again, in the interest of a fair trial, here are the orders that she is issuing. Media representatives, reporters, journalists, and anyone else claiming status as a journalist under Rule 1:19 shall be required to sign in every day by the clerk and show proof of registration with the SJC, Public Information Office. There shall be a designated seating area for media, and there's no seat reserved. So if you get up, it says there may not be a seat for you when you come back. You can't just say whatever it is the kids say when they get up and they want their seat reserved. And it says here that there will be even if you want to post things on the internet like live tweet, you need to have permission from the court. So I had some questions about this order myself. They're going to allow one pool video camera and one pool still camera. They're not going to allow any photography or any video prior to the judge taking the bench or after the judge leaves the bench. And we've seen a lot of that in the hearings that we're covering. You know, they'll be filming during the court chatter, watching Karen and her attorneys come into the courtroom, watching Lally and his team come into the courtroom. They sort of zoom in on Karen before court starts. And then after the proceedings are over and the judge leaves the bench, we've seen a lot of hot mic moments and a lot of zooming in on things. And they're not supposed to be doing that, and they're not going to be allowed to do that. So they're not allowed to even start filming until the judge takes the bench, and they may have to stop immediately after recess and adjournment. And here it says here, except as permitted in 1 and 2 above, no person is permitted to film, photograph, record, and stream, transmit, or broadcast court proceedings at any time through photographic or electronic recording devices, including still or video cameras, cell phones, smartphones, tablets, laptops, audio recording, or transmitting devices, or any other electronic device with communication capabilities. Except as permitted in number 1 and 2, no person is permitted to use any electronic device with communication capabilities to submit updates to social media during the proceedings. So again, is nobody allowed to live tweet during this trial? I'm confused. And then again, they are not going to allow any of the cameras or TV stations to record any sidebar conferences, and the mics must be turned off. All microphones shall be shut off during the sidebar conferences, and they shall not zoom or manipulate the camera and focus so as to reveal accidentally or otherwise documents of attorneys, the clerk of the court, or the judge, or any other documents not admitted as trial exhibits or not published to the jury. Kind of like this. On Larry's stream, he caught this, and I didn't have the video that he had. But look what the camera did. Focused right in on Karen's cell phone, on the screen of Karen's cell phone. Can you believe it? Well, yeah, they're not allowed to do that, and they're not supposed to be doing that. So at least they've been admonished. Doesn't say they can't zoom in on the defendant. And about the sidebar conferences, this is interesting because if you watch the Maya Kowalski trial with me, Recovery Addicts, who did a great job live streaming the trial, he had a Zoom feed, and he could often pick up what they were talking about at sidebar conferences, and it was on there. It was on the public Zoom feed. So we heard that stuff. We're not going to hear it during this trial unless it seems like they don't really know how to use Zoom. So I hope whoever's using their Zoom is abiding by this order, whoever's monitoring their Zoom or whoever's running it. Media requests for inspection or copies of trial exhibits shall be made on a form in a manner prescribed by the court. And so the court is going to allow media access to some trial exhibits. They are not going to allow any filming or contacting of jurors prior to their discharge. Jury selection or jury impoundment is going to begin on April 16th at 9:30 a.m. in the Norfolk Superior Court. They are going to allow cameras for the statement of the case and the preliminary jury instructions by the judge, and then the cameras go off and we will not see the rest of the process on TV, but whoever is sitting in the courtroom will be able to sit there. So the public at large, media, journalists who are sitting in the courtroom can watch the rest of jury selection. Contrast this to the Chad Daybell trial, in which they just showed the entire process of jury selection on TV. I am also confused here about restreaming. So anybody who's planning on restreaming this is not allowed to unless they get express permission from the court. I'm not really sure. And this is interesting too. We're going to contrast this also with the Maya case. All persons subject to this order, including all media representatives, reporters, and journalists, are prohibited from interviewing or attempting to interview anyone, any person in the courtroom or the courthouse. No person shall interview with intent to relay, transmit, or distribute publicly the contents of that interview any other person in the courtroom or courthouse. The court prohibits any person from taking photographs, filming, recording, or broadcasting events occurring outside the courtroom and other areas of the courthouse. So I'm confused by this too. Does this mean that someone like Jules, who at the Maya Kowalski trial was in court every day as an observer and would call in to certain YouTubers to talk about what happened in court that day and how the jury was reacting to it and what the jury appeared, the appearance of the jury and what they were listening to and what they weren't listening to and who was taking a lot of notes? Is that what that means? Or does it just mean you can't interview them or attempt to interview them while in the confines of the courtroom or courthouse? Or does it mean anybody who was there, you're not allowed to interview them at all, and they're not allowed to talk about what they saw in the courtroom on, let's say, a YouTube channel? I don't know. This is concerning to me. Again, it's not very clear the way it's worded. And then it says a violation of any of the provisions of this order may constitute contempt of court. Court officers may eject or exclude entry to any person believed to have violated any provision of this order. What say you, my friends? What say you? Jacko606 says, with all these trials on TV, we see such judicial incompetence and emotional versus logical juries. This is scary for our constitutional process. I agree. I agree. Mindy says not inside the courthouse, meaning you just can't interview them. But then it says no filming, recording, or broadcasting events occurring outside the courtroom and other areas of the courthouse. So I don't know. I don't know if they're not allowed to interview them while they're in the courthouse or if they were in the courtroom or the courthouse. It's unclear. It's unclear to me. Gally May 93 says, I'm retired law enforcement. This whole case is so embarrassing and corrupt. Nevaeh says the public can't be admonished that way. There is no way to enforce it. Oh, contempt of court. Kim O'Brien says nothing she wrote is clear. It's all vague. Yeah, I agree. And Doreen says so much for our First Amendment rights, my friends. So much for that. All right, we'll do a quick review, or I will give you a quick review of what the Boston Globe is asking for and why they're asking for it. Okay, so they're looking for a motion to terminate or modify the impoundment orders that we've seen in this case. And you may recall that in January, the defense filed a motion to dismiss the indictments based on information that was given to the grand jury, the state grand jury. And that was impounded. And the Commonwealth filed an opposition to that on February 21st, and that was not impounded. So we went over the Commonwealth's opposition to that motion because that's the only thing that we could get our hands on. The reason that the defense impounded their motion and exhibits is because it contained grand jury testimony, and grand jury testimony is supposed to be kept secret. Then in March, the defendant filed a supplementary memo in support of their original motion, which contained some stuff from the federal grand jury of the investigation of the investigation, and that was impounded. But that was also impounded due to the instructions that were given to both sides by the U.S. Attorney's Office that they should guide their actions accordingly with regard to what they were releasing publicly and what needed to be impounded. And then the Commonwealth filed a supplementary opposition to that on March 11th, and that was impounded. The Boston Globe says the public has a right to know. They have a right to have these documents unsealed. And yes, grand jury secrecy is important, but it's not absolute. And the public's right to access court documents outweighs the interest in grand jury secrecy. They are not moving to unseal the injury photos or the autopsy photos. And they say there's great public interest in this trial, so much public interest in this trial. And then they start talking about constitutional rights and freedom of speech and journalistic freedoms. And that kind of just makes me chuckle because I don't really think that the court is paying attention to the rights of at least the people outside of Massachusetts. But again, my personal opinion. It is my own personal opinion, and I'm entitled to it. But I wanted to read you a little portion of page 11. I don't think that the defense is going to oppose this motion because, quite frankly, everything that the Boston Globe is asking to be released benefits the defense, in my opinion. And when we looked at the Commonwealth opposition, they put tons of stuff in there that probably should have been impounded because there were a lot of things in there that probably will not be admissible at the actual trial that happened during the state grand jury. For example, all the things that happened in Aruba that were testified to. There were certain troopers who read into evidence other troopers' reports that may not be admissible. At Karen Reed's trial, there were certain text messages allegedly from between Karen Reed and Brian Higgins, who is the ATF officer who was present on the night in question. So, you know, it was interesting that the Commonwealth did not impound that motion because they wanted all of that stuff to be publicly released, in my opinion, because again, it would paint a picture of a woman who intentionally wanted to murder her Boston police officer boyfriend, who she apparently loved. So, you know, I think in this case, I don't know what the judge is going to do with this, but it's going to be interesting to watch this hearing, which is what we are going to do. What did I miss in Aruba? Oh, Jenny. Somebody fill Jenny in. Holly Mack, hi. Does this mean someone like you can't stream the trial without permission? I do not know. That's a great question, but you know who does this all the time? Recovery addict, and I'm going to ask him. But it will be live streaming on, you know, platforms, I think, like Court TV and Law and Crime. So does that mean we can't rebroadcast that live without getting permission from the court? I don't know. That's a great question. That's what I'm wondering about myself. Well, I am going to line up the court feed for you. This is a good time to hear a word from the sponsor of today's show. I don't know if you guys heard about this, but AT&T recently announced that 74 million customers of AT&T, both current and present, current and past, before 2019, that their information, including social security numbers, was leaked to the dark web. So if you were or ever have been a customer of AT&T, you might be frightened that your information is out there on the dark web, including your social security number, date of birth, address, phone number, and name, which leaves you open to identity theft which is something that if you've ever had to deal with, you know how horrifying it can be. And in that vein, I bring to you the sponsor of today's show. Did you know that the odds of falling victim to online crime are 1 in 4? Online crime is soaring. It's time to get smart about online safety. That's why I've been using Aura, the sponsor of today's video. Aura provides everything you need to protect your privacy, identity, finances, and your family in one easy-to-use app. Do you even realize how much of your personal information is already out there, being sold by data brokers to scammers, spammers, and anyone else who may want to target you? Well, if you Google yourself, you may find something like this. And it may shock you to know that your full name, home address, email address, health records, and even relatives, it's all out there. That's one of the reasons you need Aura. Aura shows you which data brokers are selling your information and automatically submits opt-out requests on your behalf. Not only does cleaning up this information reduce the amount of spam that you get, but it will protect you from hackers who could use the information to help them access your social media accounts, bank accounts, and other sensitive information. Aura also helps protect me and my family from online threats by providing antivirus and malware protection, a secure VPN with military-grade encryption, credit monitoring, spam call protection, parental controls, password management, identity theft insurance, and more, without having to download several different apps. It's really easy to set up. And best of all, I get everything at one affordable price. With the family plan, Aura will help you protect your kids by blocking harmful content, managing how much time they can spend online, and providing you with peace of mind while they game with cyberbullying and online predator threat alerts. I value my privacy and my online safety, and I value yours too. So go to aura.com/Melanie Little to start your 2-week free trial, because you can't put a price on peace of mind. I've also put the link in the video description below. You can thank me later. And starting at only $12 a month, I highly recommend. That's all I can say. You can't put a price on protecting yourself and your online safety. And if you were or have been an AT&T customer or are currently, you might want to look into it. And what can you lose with a free 14-day trial? Just make sure you use my special link. I've linked it below the video as well. And I just, as much as I complain about Verizon, I thank myself, thank God that I've had Verizon for 25 years probably, because AT&T doesn't really work in my area. So I know some of you are not as fortunate and you've had AT&T because it works in different places. So what else, my friends? I have Boston TV up right over here. So we are on Boston 25. We're going to be ready to go as soon as they start. They say they are going to be streaming it live. So I've got it up for you. Questions, concerns, comments. It is current. We have 10 minutes before we start. So we've got some stuff there's nothing has been filed that I can see today. Today is the 9th. That order about the media protocol and coverage was filed yesterday. The Boston Globe motion was filed on the 5th of April. And I wonder if the Commonwealth is going to oppose that motion. They haven't filed any opposition. Will they be there to argue it? Will they be there to keep all that other stuff in the grand jury testimony that defense referenced in the motion that we went over? Oh, we didn't go over the motion. We just went over the Commonwealth's opposition, but they brought up a lot of stuff in there. And of course, as every side does, they bring up what is most favorable to them. So you can assume that there was a lot of stuff brought up in the federal grand jury and the state grand jury that is going to be beneficial to the defense. But seeing the way that Judge Cannoni has ruled on a lot of these motions, I'm curious to see what she's going to do with this. Let me know what you think. Yeah. So Angela, that will be on Friday. The motions to not include stuff in the trial. All the motions in limine have to be filed by Friday. I haven't seen any filed yet. I have the court docket up here. I just looked at it. So motions in limine are motions that are made prior to the start of the trial to address evidence that each side wants excluded during the trial, and they need to argue that, and any evidence that they want included in the trial that may become an issue with the other side. So Friday should be very, very interesting. And we've talked about what kind of motions they think they're going to make. We think that they're going to make, and which evidence we think they may try and exclude. Some of this Aruba stuff, some of this Higgins and Karen stuff, anything that's more prejudicial than probative. The judge also said she would entertain a motion to exclude the DNA on the alleged not hair that was found on the bumper because the Commonwealth could not get the testing done in time. So yeah, Emmy says, I'm really concerned about the restreaming part. I don't know. I'm going to have to check with some of my sources and see what they say about it. Travel says, I don't see how they can enforce people restreaming trial. Wouldn't Court TV have to copyright strike people? I don't know. Sometimes, and I know because Recovery Addict has to deal with this a lot when he's streaming trials in different jurisdictions. He has to get special permission if it's a Zoom feed. So maybe if it's going out on mainstream, you're allowed to. But again, you know, who wants to be threatened with contempt? We've seen what this jurisdiction has done to citizens of Norfolk County and trying to prosecute them and shut them up, basically, in a lot of different ways. If you know, you know. So who knows? I don't want to be threatened with contempt, that's for sure. Yes, Carrie, I think a lot of people feel this way. She says, I think the Commonwealth wants the judge to strike it, meaning the DNA of this alleged hair, not hair, to save the embarrassment of it not being a human hair. That is what a lot of people have hypothesized. Just Christina, how can you copyright strike a pool camera? I don't know. I don't know if like they all have to share in costs when there's a pool camera and they have to pay to use it and restream it. Yeah, Mandy, really, if it's a Zoom feed, some of the Zoom feeds, you have to get special permission from the court to broadcast it and not just watch it yourself. So you're rebroadcasting it. Candace says it would be horrible if Brandy couldn't stream it. She has worked so hard on this case. Yeah, I mean, that goes for a lot of people. I wanted to live stream it too. I don't know if I could do it every day. I might have to just do recaps on this. Hi, Mermaid Mary RN. Thanks for being a member for 3 months. Kansas missing moms case resembles Pike County murder case. Kansas City missing moms case resembles a lot of things that I can think of, and I have some new information on that. But these women have been missing 11 days now, and there's no sign of them, and there are no search parties going on other than Rock Chalk, who is out there by herself with Carrie searching for these women. Some citizens have shown up to search for them, but they haven't seen any law enforcement searching going on. There has been no drones. There's been, it's very, very curious to me why there is no searching going on. The families have not spoken out. They have apparently been told by law enforcement for their own safety not to speak out, which is very concerning to me. There's a very contentious custody battle going on behind the scenes. And prayers up for the families of Veronica Butler and Jillian Kelly, because I can't imagine what they're going through. And they're just not allowed to talk. So it's crazy. We usually don't see that. We usually see families talking, pleading for help from the public to help find their missing loved ones. And we're not seeing that in the Oklahoma Panhandle. Yeah, for their own safety. Talk about the wild, wild west. And that's what they say. A lot of people have reached out to me from the Oklahoma Panhandle, and they say, this is no man's land. This is like the forgotten place. You don't know what goes on here. They're like, this is the Wild West. And I was really concerned for Rock Chalk but she seems to be able to protect herself. Thanks, AG, for becoming a member. All these new members. And Wim, Amy in Boston, thanks for becoming a member. Dawn, thanks for becoming a member. Fairy Raven, my favorite, one of my favorite names. Thank you for becoming a member. Buzzing for Truth, thanks for being a member for 3 months. Can you explain what they're trying to get today? I think I just did, but if you have any more questions, let me know. They want that court file unsealed. They want to know what's in that file and what is impounded. And thank you, Mermaid Mary, for your comment as well. And Deborah, thanks for becoming a member. Thank you so very much. I have Boston 25 up here, and I do not see it yet, but we are still waiting. No, that's something else. If anybody sees it come up on a different channel, let me know. We are at what? 157. Motions have been filed today, says Karen Bowers. They are not showing up on the court docket. I'll refresh it and see. They may just not have hit the computer system yet. Oh, look, I refreshed it and some things came up. Commonwealth's notice of discovery. Interesting. But it says it was received 3/26/24, but it was just logged in today. And there is a Cox Media Group joined in the motion to terminate the impoundment orders. And then there's a letter from U.S. Department of Justice Attorney Joshua Levy regarding the motion of the Boston Globe Media Partners. I want to see what he's got to say about that. That'll be interesting if he shows up or someone in his behalf. And there's a motion to waive defendant's appearance, which is allowed for today. So the defendant will not be appearing, and that has been allowed by the court. So thank you for that, for Karen, for giving us the important breaking news. NBC 10 Boston has it right now on their website. So it will be streamed in the player above. Okay, well, where's the player? I don't see any player on here. Yeah, there's a hearing at 2:00 regarding the Boston Globe's motion. Boston 25 is live streaming as well. Okay, but is it on their website or is it on YouTube? Because on their website, they've got the weather up right now. On the website. All right, I mean, I've got it up here, but this is what they're showing me. Adobe commercial. Okay, so where is this? It's on YouTube on their 24/7 page. Thank you. And that is what? That is Boston 25? No, that's from 5 days ago. Two weeks ago. All right, let's try Boston 10. Anybody have the link? Because it's just not coming up. It's on whose stream? BC 10, Boston, YouTube. Have their website. I mean, this is what it's showing me on the Boston 25 page. This is crazy. Maybe it's only local? Canton TV? Maybe because I'm out of the area? That's crazy. Click on the box next to the TV. I'm going to show you what it's showing me. Maybe if you're local, you're getting something different. The hearing will be streamed in the player above. So where is the... Boston Globe on YouTube. All right. Thank you, my friends. See, we're so collaborative here. It's very warm in New York today. It's like 70 degrees right now. It's almost time to put the air conditioning on. Why am I not seeing this? Live TV up by the temperature. Okay. Okay. Oh, for Pete's sake. Really? They're going to make me jump through all these hoops? Is it on commercial right now? Because they're showing me a commercial of Grand Cayman and Access Hollywood. There's a fire near South Station, in case anyone's interested in that. Boston 25 app. Fox 25 is now showing stock footage. It's on Canton Community TV. Okay, is that a YouTube channel? Or is that... Or do they stream like on Vimeo or something? I'm watching in Boston 25 YouTube. Okay, try that again. All right, now we got it. We're just gonna have to rewind it a little bit, but whew, it took a village, you guys. It took a village. I got it. It's live TV. You know, what are you gonna do? Sometimes if you're out of the area, they won't let you watch it. Phew. Oh, and of course the audio stinks, and there's no way to boost this. Like, I can't even hear it. Can you guys hear this? Yeah, this is the problem with Boston TV. It's so bad. Let me see if I can find something better.
Good afternoon, Your Honor. John.
Nice to see you, Mr. Albino. So before we begin, I did receive this morning a motion from...
Okay, that is just horrible. That is so distorted that I can't even listen to it. So we're going to look around. Yeah, it's really bad. Why is the audio so crappy? Rubbish. They don't have closed caption yet because they can't get the closed caption working until after it streams. Yeah, it is very, very, very bad. Oh, Amy, you sent me the link? Did you email it to me? I don't see it. All right, we'll try. While this is playing, I'll see if I can find something better.
Counsel waiving her, asking to waive her appearance today. On the motion and does not wish to be heard on the motion through counsel.
Now I can't even hear anything now. Oh, this is the worst. I mean, it just literally, like, the sound just cut out. I mean, this is their YouTube. I mean, we're just going to watch it and then we're going to have to find a better version of it. But we have no idea what he's saying. He's talking for the Globe. Epic fail. If this is the way the trial is going to be live streamed, this is going to be really a challenge. The worst. I can't even repeat to you what he's saying because I can't even hear it in my earbud. All right, I found something. I think I found a better feed.
So why don't I have the authority to hear you today on the release of the state court materials that you filed, but I have referenced in my decision?
The Commonwealth, essentially takes no position on what your authority is and what your role in the state court is. The Commonwealth can only represent what order it is bound by.
So, Ms. McLaughlin, I want to hear you on whether or not there is a docket number 201 that the Commonwealth's grand jury makes. What's the Commonwealth's position about me releasing those?
The grand jury minutes,
Yes.
the Commonwealth would oppose the release of any grand jury minutes prior to trial. The trial is imminent. These same witnesses who testified before the grand jury are anticipated to testify within the upcoming weeks. The release of their testimony prior to that trial, we don't want to cloud anyone's memory or any of the witnesses we testified to. The public will have the right to all that information when witnesses didn't stand. Under Massachusetts law, the grand jury minutes are secret, and the Commonwealth would oppose any release of the materials that went before the North Court grand jury.
Okay. So when I read Mr. Alvano's motion, I focused on the paper numbers that he cited, everything that the Commonwealth and the defendant filed under seal. You all followed your protective order that I do not have to follow. You all follow the protective order. And I considered those materials and I referenced them. They were critical of my decision, and I referenced them in the decision. So that's what I am focusing on.
If those portions, whatever Your Honor, its findings, the public has the findings made by the court. The witnesses would testify to that, their personal knowledge shortly. So the Commonwealth has an educated objection of the release of any grand jury minutes.
Regarding the pleadings.
Regarding the pleadings, if Your Honor is inclined to release pursuant to this motion, then the Commonwealth really does take a position on. Redactions could be made to any references of grand jury materials that, the Commonwealth takes no position on what Your Honor's authority is, but to the point that when we filed the materials, we were bound by this protective order to impound those.
They were perhaps.
Yes, so perhaps with redactions may be appropriate. It's unique circumstance.
It is unique circumstance, and I understand the position that the Commonwealth is in, and I understand the position the defendant was in, prudently decided not to pursue anything in court, but you had no choice, you had to be here. So, Mr. Alvano, do you believe I have the authority to do with these documents that you requested when I want to do them, right? Massachusetts law governs?
I do, Your Honor. I think, I'll go back and track on that protective order. I'm happy to submit a supplemental filing, but as I stand here today, I don't understand how a federal court judge can tell a state court judge what to do with the state court's findings.
For a case that's on for trial next week. So, I share your view. I do not have any case telling me that I have to listen to what they say I should do with this case. I'm not going to come on position to ask them whether they agree with me. So, as you all know, this case is going to trial next week, so. Although the Globe recognizes the secrecy of the grand jury proceedings, it is requesting that this court unimpound 14 days of grand jury testimony on the basis that some grand jury testimony and exhibits have been disclosed in a public court filing, and therefore the interest in grand jury secrecy are overcome by the public's right of access to court records. While it's true that some grand jury testimony has been previously disclosed to the public, I can tell you because I've read them, the majority of testimony and exhibits have not. In particular, the request encompasses videos of sane interviews and testimony of witnesses not mentioned in any public filings. So although the SJC has recognized that a limited amount of disclosure of grand jury testimony may be justified when there has already been public disclosure of that information, the Globe has not directed this court to any case law suggesting that where some grand jury information has been publicly disclosed, all grand jury testimony and exhibits lose their secrecy. And that point is clearly taken in a case that, the County Stewart case. So the Globe newspaper versus police commissioner of Boston. It's a case that plaintiff's counsel was Mr. Albano. So, should the Globe seek grand jury testimony of a specific witness whose testimony was summarized in public court filings, the court would consider such a request. However, the only kind of witness testimony, my reading of the case law, that would be subject to disclosure is that which has been summarized in a court filing. So, I am prepared to release, subject to redaction. As if you don't have enough on your plate, Mr. McLaughlin, I am going to give the Commonwealth until tomorrow morning. Proposed redactions. The defendant has waived any argument to this motion. So it's time to release the defendant's motion to dismiss. There are attachments to that by way of exhibits that are with it. I am not going to release what's docket number 201, the grand jury minutes. I am not going to release the grand jury minutes. I am going to release paper number 228, the supplemental memorandum in support of defendant's motion to dismiss, though it has actually a different heading. And I'm going to release the Commonwealth supplemental memorandum in opposition to defendant's motion to dismiss, docket 232. So it doesn't give you a whole lot of time, Ms. McLaughlin, and I do know just that there were police reports attached to the motion to dismiss the Odell motion.
Okay.
That include dates of birth and addresses of witnesses, so I will redact those. It's certainly, you're not interested in those, Mr. Albano. So I need to redact any identifying information, and what the Commonwealth might think should not be released pursuant to this order. It doesn't stop you from filing a motion to intervene in the federal court, obviously, for anything else. All right.
Understood.
All right. Okay, can you get it to me by 11 o'clock tomorrow morning?
Yes, Your Honor.
Thank you. All right, thank you very much.
Thank you, Your Honor.
All right, so Jim, we're going to take a recess before we do our other stuff, okay? Tori, we all set? I can take my computer? Thank you.
All right, please.
Goodbye.
All right, so that was horrible. That was brutal. That was brutal. And it's live, so they won't let you rewind back to the beginning of where you were. And that was brutal. And let us all hope and pray that the court stream of the live trial is not as horrific as this was. The only thing that I could gather from hearing her, I didn't even really hear her at all, was that they're going to release some of the motion. It's going to have to be redacted by 11 a.m. by the Commonwealth, and she's not going to release the grand jury minutes. So I guess we'll know by tomorrow what's been released, and we'll be able to glean some more information from the defense's motion to dismiss based on the grand jury and then what was seen in the federal grand jury. So, I mean, it's still on 25. Let me just see if this is any better. You can tell me, but I don't think it is. Maybe somebody finally found a microphone. I mean, the amount of crumpling that goes on of papers in front of microphones makes me crazy. And when I was watching the Crumbley sentencing today, there's always a cougher. There's always somebody coughing who's got a cough. And I'm convinced that people do it intentionally. So let's see if we can hear any. Poor Ms. McLaughlin was out on a ship by herself this morning, sinking because Lally didn't show up. So she's doing her best to try and argue on behalf of the Commonwealth, but this sound is pretty terrible. Tell me if it's any better. Maybe it gets better. No, there's no hope. There's no hope for that. Forget it. Forget it. It's not even worth the aggravation. So there was really nothing. There's nothing there. Can we go over this again? Yeah, if somebody ever gets some audio that actually has any rewatch potential, maybe that's why, Court TV always reposts it later. And maybe that's why Law and Crime reposts it. I mean, until they repost it, there's not a lot that we can do, but we can look at the motion papers a little bit more at length. Although, I mean, we kind of did. Here's their main argument right here. When they start talking about the community interest in this case. Defendant's prosecution has garnered significant public interest. She is charged with murdering a Boston police officer. Finally, somebody is calling him a Boston police officer, and it took the Boston Globe's motion for somebody to refer to Officer John O'Keefe as a Boston police officer. And has alleged that she is the victim of a cover-up perpetrated by the Canton police and local prosecutors. The case has divided the town and put Canton public institutions under scrutiny as defendant supporters have rallied around her and decried what they claim is a corrupt prosecution. In a case such as this one, the transparency of the proceedings is crucial to the public's understanding and acceptance of the judicial process. When a shocking crime occurs, a community reaction of outrage and public protest often follows. Thereafter, the open process of justice serves an important prophylactic purpose, providing an outlet for community concern, hostility, and emotion. The crucial prophylactic aspects of the administration of justice cannot function in the dark. No community catharsis can occur if justice is done in a corner or in any covert manner. Okay, so they use the word prophylactics twice and then done in a corner, which is weird. It is not enough to say that the results alone will satiate the natural community desire for satisfaction. Stated otherwise, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. The nature of the parties' community interest in the case and the reason for the request thus favor terminating the impoundment order. Then they go on to address the type of information and privacy interests involved support vacating the impoundment order. The records themselves address the legitimacy of the prosecution, a highly publicized matter that is the subject of legitimate public concern and controversy. To the extent any portion of the documents implicate legitimate privacy interests, a blanket impoundment of the entire document is not required. And I think that's what she did here. She said, we're going to make certain redactions. I'm not going to release the entirety of the grand jury minutes that were attached as an exhibit, but the motion papers are coming out, and Commonwealth, you have, I think she said until 11 a.m. tomorrow to redact the parts that you believe will be redacted, should be redacted. And they start talking about constitutional rights. And remember, these are the papers of the Boston Globe, not the Commonwealth, not the defense. The fourth factor to be addressed, constitutional rights, does not weigh in favor of impoundment. The burden is on the party seeking impoundment to demonstrate a substantial probability that permitting access to the specific documents at issue here will prejudice her fair trial rights. So again, the Commonwealth is the one seeking impoundment. No, actually, I don't think either one of them sought impoundment. The defense did not seek impoundment. The defense was told by the U.S. Attorney's Office to make sure they don't release certain things that were released to them. So I don't know. But in any event, it seems like from what we could glean from that hearing that parts of it are going to be released tomorrow. So we will have more paperwork to go over tomorrow. Cites a whole lot of case law. In fact, we saw her waving around a law book while she was talking to Ms. McLaughlin, who looked scared. And the judge was smiling a lot today, which is kind of unusual for her, and laughing. Maybe it was interesting that we really didn't have sound because we could gauge facial expressions. Kind of got to guess what was going on. Moreover, the impoundment order must effectively serve its intended interest, i.e. the harm from public access must be one that closure would prevent. And they say, no, 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 based on freedom of the press and the rights, the Declaration of Rights of the Commonwealth, freedom of speech, freedom of the press, and of assembly. Freedom of assembly. In the interests of all of those things, Judge, you should really unseal or unimpound these documents. They say the Commonwealth's long common law tradition of public access to judicial proceedings and records viewed in light of the emphatic protections for free speech and the press in Article 16, thus amply support a state constitutional right of access justifying the requested relief. Conclusion: for the foregoing reasons, the Globe respectfully requests that the court vacate the impoundment order entered in this case, or in the alternative, modify the order by redacting only those portions of the record for which the parties can satisfy their burden of proving good cause. That's what the motion was, and we think we know a little bit about what the decision was, but horrible audio, and that's why I don't like to stream these things live, but sometimes you just gotta roll with it. Sometimes you gotta go with the flow. Nicole says, I think Andy Bev got a crush on the guy from the Boston Globe. The last guy that came in, he was from Boston Magazine, right? And that was a different attorney. This is not the same attorney, but I know what you're saying because it was a different attorney. And he was for the, I think, Boston Magazine, because that's when they wanted the notes from Gretchen Voss's article. Oh, thanks. Thanks. Young Jerk said that I could stream his video. Oh, hey, thanks. Thank you so much. You want me to play it right now? We have permission. Thank you for your permission. I never, people tell me this one's streaming at that one, but I would never, ever restream another creator's content without permission. So thank you for that. We're going to, let's go over there. And while we are there or later, or I'll link the channel below, subscribe to the channel. You guys are awesome. Hang on a second. How did you, you must have some super cool, fancy audio booster. I'm really not a techie, so I can't do this very well, but I do what I can. All right, let us go back and we're going to watch this again, everybody. Yay. Thanks to the Young Jerks.
What is this? I think it's the 350, right? It might be. I think so. Like you're right on top. But go fast. You may have to see if it's.
Oh, I see you. Somebody gave me the Zoom ID and I tried doing that, but it wasn't the right number. So everyone go subscribe to Young Jerks after this.
Now, open your meeting, seated. My name will make sure your cell phones locked and put away.
Judge 22 CR 117, the Commonwealth versus Karen Reed. Can I have the parties for this motion identify themselves for the record, starting with the Commonwealth?
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
And the moving party?
Good afternoon, Your Honor. John Albano for the moving party.
Nice to see you, Mr. Albano. So before we begin, I did receive this morning a motion from Ms. Reed's counsel asking to waive her appearance today, as well as her counsel, stating that she takes no position on the motion and does not wish to be heard on the motion through counsel. I allowed that motion. And I also want to let you all know that when I read Mr. Albano's pleading, it was clear to me that the U.S. Attorney's Office was an interested party. So I, as you know, ordered the moving party to give notice to the U.S. Attorney's Office if they wanted to come here and be heard. They have sent a letter to me this morning that was docketed and put in the file, and they're not here to address this motion. So with that, I will hear from you, Mr. Albano.
Thank you, Your Honor. I don't want to repeat what I put in the brief, so
It's okay. Say whatever it is you want to say.
I thought maybe I should focus on the two issues that I expect are most significant here. One is, it seems clear that the impounded materials do include some grand jury materials, and obviously there's a general rule of grand jury secrecy. That we would submit is not always the case. If witness is impeached with grand jury testimony, the trial isn't closed. If there's a perjury conviction, or perjury trial rather, that's not closed, even if it's based on grand jury testimony. And here, we submit that the detailed opposition, the 49-page opposition to the defendant's motion to dismiss, contained a significant amount of references to grand jury testimony. So I can't pretend I know what's in the impounded papers, but it does seem reasonable for me to suggest that that disclosure does mitigate the extent to which the rule of grand jury secrecy applies. And the other factor I would cite here is that these materials were submitted to the court as grounds for a ruling by the court, which the court made in denying the motion to dismiss the indictment. So to that extent, it is that the materials are sort of the classic judicial document which the public has a right of access to. And the last thing I'd say on this is that, again, I haven't seen what's impounded, but the alternative argument I'd make is if there is some type of sensitive grand jury material which has not already in substance been disclosed, then an alternative available is to redact just those portions of the documents and allow the rest to be made public. So that's sort of my pitch on the grand jury issue. The other issue I seems to me is relevant is the fair trial rights with a trial coming up and a disclosure of what has till now been impounded material if it's not in substance the same as the Commonwealth's opposition. And obviously there has been a lot of publicity about this case. That's just true. But the SJC has said that even in high profile cases, voir dire and jury instructions can be sufficient to protect the defendant's fair trial rights. The other two things I'd say here is I think it's significant that the defendant apparently has said she takes no position on it. So there's less of a concern, I'd say, about the defendant's fair trial rights being prejudiced. And from a legal perspective, I'd also say this. There is, and we put it in our brief, case law that says a closure order, an impoundment order should be effective at what it's trying to do. And in the fair trial context, the Press Enterprise case we cited, in that case, it was whether a pretrial hearing was going to be open or not. And the trial court judge closed the hearing, finding that there was a reasonable likelihood that an open hearing would prejudice the defendant's fair trial rights. And the U.S. Supreme Court said, you have to go higher than that. It has to be a substantial probability that the defendant's fair trial rights would be prejudiced and that the closure order will be effective. And here I would say that given the publicity that this case has engendered, the notion that the incremental effect of releasing the motion papers on the motion to dismiss, that would pose a substantial likelihood of a threat to the defendant's fair trial rights. I'd say, again, I don't have the benefit of seeing the papers, but we'd suggest that's not sufficient to justify a continued impoundment order, given the Commonwealth's filings and given the filing and given the fact that the motion has been ruled on.
All right. Thank you very much. Ms. McLaughlin, I know I have nothing in writing from you, but I know that you're getting ready for trial on Tuesday.
Yes, Your Honor.
That's fine. I'll hear you.
Your Honor, essentially the Commonwealth takes no position on this motion. The Commonwealth received the confidential federal materials pursuant to a signed protective order that the Commonwealth has signed, that all filings made to this court that reference or include any references to the federal investigation would need to be filed, impounded, and under seal. Therefore, that what the Commonwealth has done as it is a party to that protective order.
Except for like you didn't impound your first opposition to the motion, which was like, I don't know, 49 pages or something, because we went over that at length. So, a little disingenuous, but I don't know. Let's see if the judge lets her get away with that. Because now we're watching this with fresh eyes because we couldn't hear it the first time, and now we just have crappy video, which is no fault of the streamer on this. This is the Zoom feed, I imagine, and that's just as crappy. So we can't see, but at least we can hear. We can hear all the sighing, and all of the deep breaths, and all the heavy breathing.
Your Honor, I'm unaware if we've previously filed the protective order. If Your Honor has not received that, I can file that.
I have not.
Okay, then the Commonwealth would move to file the protective order pursuant to an impoundment order of this court.
Are you going to come back in on that, Mr. Albano?
I should look at it first.
Your Honor, within the protective order.
Oh, little cupcake, you're right, with the girly laughing and the giggling, and she's all red. Maybe it's hot in that courtroom. I don't know. She's like, it's crazy.
It does reference the jurisdiction of any disputes arising out of the protective order would be before the federal court. Therefore, essentially, the Commonwealth takes no position, but is bound by the federal protective order that was endorsed by Judge Casper on February 20th, 2024.
Wait, who's Judge Casper? There has been no other judge in this case since February of 2024. So does anybody know who Judge Casper is? She says that Commonwealth takes no position on this motion, except for we are a party to a protective order that the U.S. attorneys, was the federal judge. Thank you, Mindy. Thank you, Sons 107. Interesting. Okay. Snatch, you're funny. All right. I'll take good audio over video if I had to pick. Me too. Me too. Because it's kind of like, listening to the radio or a podcast on audio.
I'll hear you, Mr. Albano.
If I have it straight, then there is a distinction between documents filed with the court and documents in the custody of the Commonwealth and the defendant. And I wasn't aware of Judge Casper's protective order, but typically, in my experience, the protective order says you, the parties, cannot release this information. And And this one apparently said, and by the way, if you file it in court, you should file it under seal. Having it been filed with this court, however, it is this court's papers, not the federal court's papers. So I don't, while of course one would take into account the federal court's protective order, I would say, and God, I hope I haven't read it, so I might be wrong, but I would say the protective order binds the parties, not this court.
The protective order indicates that not if we file it, we should impound it, that if we file, we must impound.
So that's been done already.
That has been done, Your Honor.
All right. Does the Commonwealth, I would like the Commonwealth to address the concerns that we have on me releasing these state court pleadings. Are you bound by the protective order such that you can't even address that because they tell you that you have to go to federal court to address that?
The way the protective order is written indicates that if any party seeks to modify the protective order, the exclusive jurisdiction would be within the federal court.
So neither party is seeking to modify the protective order.
The Commonwealth has not sought to modify any protective order, nor has any party filed a motion to intervene in the federal court or seek this material from the federal court or address the motion before the federal court.
So why don't I have the authority to hear you today on the release of the state court materials that you filed, but I have referenced in my decision?
The Commonwealth, can essentially takes no position on what your authority is and what your role within the state court is. The Commonwealth can only represent what order it is bound by.
So, Ms. McLaughlin, I want to hear you on whether or not there is a docket number 201 that are the Commonwealth's grand jury minutes. What's the Commonwealth's position about me releasing those?
The grand jury minutes?
Yeah.
This is triggering me. It's triggering me back to law school. I had one law professor that had a deck of cards, and he would put everyone's name in the class in the lecture hall on a card, and he would shuffle the cards, and they would draw a card, and he would say, "Mr. Smith, please stand up." And then he would question you about the 400 pages of reading that you were supposed to have done the night before. Tell us the holding in, pick a case. Brown v. Board of Education. And you'd be put on the spot, and it was 8 a.m. You'd be sweating bullets, and you better hope you did that reading the night before. But this is like so law school. She's like, I want to hear from you why this, and this. Oh boy, let's see what happens here. She's wearing a sweater, which
the Commonwealth would oppose the release of any grand jury minutes prior to trial. The trial is imminent. These same witnesses who testify before the grand jury are anticipated to testify within the upcoming weeks. The release of their testimony prior to that trial may, don't want to cloud anyone's memory or anything that they previously testified to.
We don't want to cloud any of the witnesses' memory about what they're going to testify to. Oh, wait, did everyone forget? For those of you who don't know, that Jen McCabe and Kerry Roberts made a timeline before they testified in front of the grand jury. They got together, they sat around, and they made a timeline, and it's in writing. And that was referred to in some of the papers that we just found out about. So I don't think their testimony is going to be influenced because they've got that timeline. I hope they introduce that as an exhibit at the trial. Isn't this the timeline that you two formulated together to remember your testimony, to keep your stories straight? Why did you make this timeline? Because remember, the state grand jury that convicted Karen Reed did not sit until May of 2022. Officer John O'Keefe was found dead January 29th of 2022. And these witnesses did not testify in front of the state grand jury until several months later. Yes, they did a timeline. Where is that timeline? We want to see the timeline. I can't wait to see the timeline. Courtney says, yeah, we don't want the discrepancies of their testimony out before the trial. Right. Because it's all going to be brought up. Yep. Those two did a timeline. Yep. It was in some of the papers that we went over recently. Oh, I don't want to make her feel bad. Can't wait to see it.
The public will have the right to all that information when the witnesses take the stand.
Nope.
Under
Nope.
Massachusetts.
No, that's not the information that we want. We want the information that's going to be inconsistent with the information that they're going to now give on the stand. And the inconsistencies in the statements that they gave in front of the state grand jury, and then when they testified in front of the federal grand jury, and all those prepping conferences or just conference calls that Lally had with these witnesses before they testified in front of the federal grand jury, which is completely 100% improper, by the way, because he does not represent them. They have private attorneys. Many of them have been called in on Rule 17 motions, and their attorneys have appeared for them, arguing why they should not have to turn over their phone records, Google searches, and other things. So I know she's dealt a pretty rough hand here, but that argument, if I was the judge, would not hold water with me.
This law, grand jury minutes are secret, and the Commonwealth would oppose any, release of the materials that went before the Norfolk grand jury.
Okay. So when I read Mr. Albano's motion, I focused on the paper numbers that he cited, or everything that the Commonwealth and the defendant filed under seal. You all followed your protective order that I do not have to follow. You all followed the protective order. And I considered those materials and I referenced them. They were critical in my decision, and I referenced them in the decision. So that's what I am focusing on.
If those portions, whatever, Your Honor, its findings.
Wait, in her decision, did she already write her decision and she's just hearing this as a matter of course? Hang on a second. Got to hear that again.
Order. And I considered those materials and I referenced them. They were critical in my decision, and I referenced them in the decision. So that's what I am focusing on.
If those portions, whatever, Your Honor, its findings, the public.
Thank you guys so much, but somebody sent me Levy's letter, so we're going to go over it right after we're done watching this hearing. So yeah, I can't wait. It's going to be like a real reaction video because we're going to read it together.
Has the findings made by the court. The witnesses would testify to that, their personal knowledge shortly. So the Commonwealth, as in any case, would object to the release of any grand jury minutes.
But regarding the pleadings?
Regarding the pleadings, if Your Honor is inclined to release pursuant to this motion that the Commonwealth, really does take no position on, redactions could be made to any references of grand jury materials that, the Commonwealth takes no position on what Your Honor's authority is, but to the point that when we filed the materials, we were bound by this protective order.
So they were impounded.
Yeah, okay, I think you're right, Emmy. Thanks for pointing that out because my brain is kind of fried right now. But yeah, I think that's what she meant when she made the decision denying the motion to dismiss the indictments. She's saying that she did read all of that stuff and considered it carefully in her decision. And now she is waving her arms about. She needs a fan like this. Little prop for the stream, guys.
Yeah, so perhaps the redactions may be appropriate. It's a unique circumstance.
It is a unique circumstance, and I understand the position that the Commonwealth is in, and I understand the position the defendant was in and prudently decided not to pursue anything in court. But you had no choice. You had to be here. So, Mr. Albano, do you believe I have the authority to do with these documents that you've requested what I want to do with them and what I think the Massachusetts law governs?
I do, Your Honor. I think, again, I'll go back, track down that protective order, and I'd be happy to submit a supplemental filing. But as I stand here today, I don't understand how a federal court judge can tell a state court judge what to do with the state court's files.
For a case that's on for trial next week. So I share your view. I do not have any case telling me that I have to listen to what they say I should do with this case. And I'm not going to put the Commonwealth in the position to ask them whether they agree with me or not. So as you all know, this case is going to trial next week. So
Wait a second. What did she say? I'm not going to give the Commonwealth an opportunity to disagree with what?
and I'm not going to put the Commonwealth in the position to ask them whether they agree with me or not. So as you all know, this case is going to trial next week. So
this case is coming to trial. This case is coming to trial next week, come hell or high water. We are picking that jury on Tuesday, and there is no stopping the steamroll now, folks. We're going. I have it on my countdown today. I think it's on my thumbnail. I think 7 days.
Although the Globe recognizes the secrecy of the grand jury proceedings, it is requesting that this court un-impound 14 days of grand jury testimony on the basis that some grand jury testimony and exhibits have been disclosed in a public court filing, and therefore the interest in grand jury secrecy are overcome by the public's right of access to court records. While it's true that some grand jury testimony has been previously disclosed to the public, I can tell you, because I've read them, the majority of testimony and exhibits have not. In particular, the request encompasses videos of SANE interviews and testimony of witnesses not mentioned in any public filings. So although the SJC has recognized that a limited amount of disclosure of grand jury testimony may be justified when there has already been public disclosure of that information, the Globe has not directed this court to any case law suggesting that where some grand jury information has been publicly disclosed, all grand jury testimony and exhibits lose their secrecy. And that point is clearly made in a case that, the Carol DeMady Stewart case. So the Globe newspaper versus police commission.
This is when she's going to start start waving the book around. Look, she's got them all behind her too. I wonder if these are false front books, you know, like you can buy for a library in your home, or if they are actually real law books that, you know, nobody uses anymore because they smell musty. And, you know, there's this thing called Westlaw, which is actually like online legal research. So the circus tent is going up no matter what, says Joseph Kane. And thank you, Dudley Do Right, for emailing me all of the documents from today. So we will take a look at all of them right after this.
Of Boston. It's a case that plaintiff's counsel was Mr. Albano. So should the Globe seek grand jury testimony of a specific witness whose testimony was summarized in public court filings, the court would consider such a request. However, the only part of the witness testimony, my reading of the case law, that would be subject to disclosure is that which has been summarized in a court filing. So I am prepared to release, subject to redactions. And as if you don't have enough on your plate, Ms. McLaughlin, I am going to give the Commonwealth until tomorrow morning at 11 o'clock to make proposed redactions. The defendant has waived any argument to this motion. So it's up to the Commonwealth. So I am inclined to release paper 199, which is the defendant's motion to dismiss. There are attachments to that by way of exhibits that are with it. I am not going to release what's docket number 201, the grand jury minutes. I am not going to release the grand jury minutes. I am going to release paper number 228, the supplemental memorandum in support of defendant's motion to dismiss, though it has actually a different heading. And I'm going to release the Commonwealth supplemental memorandum in opposition to defendant's motion to dismiss, docket 232. So it doesn't give you a whole lot of time, Ms. McLaughlin, and I do know just that there were police reports attached to the motion to dismiss the Odell motion.
Okay.
That include dates of birth and addresses of witnesses, so I will redact those. Certainly, you're not interested in those, Mr. Albano. So I need to redact any identifying information, and what the Commonwealth might think should not be released pursuant to this order. It doesn't stop you from filing a motion to intervene in the federal court, obviously, for anything else. All right.
Understood.
All right. Okay, can you get it to me by 11 o'clock tomorrow morning?
Yes, Your Honor.
Thank you. All right, thank you very much.
Thank you, Your Honor.
Wow, that was cool. Thank you so much to Mike from Young Jerks, who allowed us to restream his stream because his stream had amazing audio. And apparently that was the stream of Canton Community TV, I believe. So listen, it's so nice when everyone can work together. And I would never, like I said, stream another creator's work without explicit permission. And he did come in and give permission. So thank you for that. I find it really, really just rude and lazy when people stream other people's content for no other reason than to either, you know, criticize them or to, you know, because they can't find it themselves. So for those of you on the replay, you might have had to fast forward a little bit through the middle here where we were looking all over to try and find a feed that had decent audio. And in the end, Mike came through for us. So thank you, Mike. Email me if you want me to come on your show. Happy to do so. Okay. Let's take a look. Thank you to those of you who emailed this to me. Let's take a look first at Levy's letter, which I'm going to have to supersize for you because it is a very small font. And this is the AUSA's sort of opposition or just their letter indicating their position on the Boston Globe's motion. If we can. I don't know. Oops. All right, I'm going to pull it up a different way. Here's the Boston Globe article that I was going to look at, but wait, let's go here. All right, this was filed, today's the 9th, right? This was filed this morning, 9:54 a.m. from Joshua Levy, who, as you know, is the acting U.S. Attorney for the District of Massachusetts. It was dated yesterday. And it is a letter to the judge. It says, Dear Judge Cannoni, the U.S. Attorney's Office received a copy of the motion of the Boston Globe media partners to terminate or modify impoundment orders, and the court's order tentatively setting a hearing on that motion on Tuesday, April 9th. The court may anticipate that the U.S. would respond to that motion either by filing a brief in this court or appearing at any hearing on the motion. However, because the United States is not a party to this action, authorization from the Department of Justice is required before my office would appear or file a statement of interest pursuant to 28 U.S.C. 517. I cannot say at this time whether the U.S. Attorney's Office would seek such authorization or whether any such authorization would be granted. Nevertheless, I write to advise you concerning the applicability of the federal court protective order. As the court is aware, to the extent the impounded filings at issue in the motion reference or include materials produced by the U.S. Attorney's Office in response to the parties' January 18th, 2024, joint request under the Department of Justice's 2E regulations. Those materials are subject to the protective order entered by the United States District Court for the District of Massachusetts on February 20th of 2024. That protective order was the product of discussions among my office and the parties to this action. Neither the parties themselves nor any third party, including Boston Globe Media Partners, have sought to modify that court order. It remains in full force and effect. So that is their position on the matter. Let's take a quick look at what the Commonwealth exchanged today, because thanks to Dudley Do-Right, who emailed this stuff to me, we have access to everything. You guys are so amazing. All right, that was the first thing. Here's the Commonwealth's notice of discovery. It's their 34th. Anybody's good at Roman numerals, tell me if I'm wrong. XXXIV, their 34th notice of discovery in this case. Now comes the Commonwealth in the above captioned matter and indicates that of this date, the following discovery and materials have been provided to the defendant through defense counsel. So this is stuff that they may have turned over just today. Number one, copy of Massachusetts State Police case number 22-1-1233, report number 87 with associated notes, 10 pages. It's a 2022 police report. I'm assuming it's from the date of the incident, but I don't know. Copy of discovery materials provided to counsel of record in relation to Norfolk Superior Court docket MSP BWC of arrest from October 11th, 2023. MSP CSS crime scene photos of search warrant of residence. Files provided by third-party intermediary Norfolk Superior Court video. MSP case report files. That's a 2023 case. Anybody know what that is referencing? Is that Aiden Carney stuff from October of 2023? MSP BWC of arrest? Yeah, that's Aiden stuff. Body worn camera. Massachusetts State Police body worn camera. Okay, from the arrest of October 11th. Interesting. I mean, are they going to try and get all this stuff into evidence? I don't think that's going to be allowed in. That'll be a subject of the motion in limine, a motion in limine on Friday, and they just turned this over. Copy of the grand jury minutes, November 28th of 2023. So that must be a federal grand jury or Aiden's grand jury. I don't know. Copy of grand jury minutes, December 5th, 2023, 70 pages. Copy of grand jury minutes, December 19th, 2023, 46 pages. Respectfully, love XOXO, Adam Lally. This is dated 3/22 of 24, but it was just filed today, 4/9/24. This is all Aiden's grand jury. How is this relevant? Right, Jennifer, exactly. How is this relevant? And Mrs. Karen's defense team got Aiden's grand jury transcripts before his lawyer got them. Wow. They're trying to link Karen into Aiden's. How does that have any relevance here? How does it have any relevance here? Am I losing my mind? Anyone? Really? So they're saying we're exchanging this with you. Have they filed their certificate of compliance? Let's look, because Dudley Do-Right sent me all the info that was filed today. Cox Media filed a motion, just joining in the motion of the Globe. So that's what that motion is about. It's really nothing for us to look at there. Motion to waive defendant's appearance was filed by Yanetti's firm and allowed. Just a little handwritten note by the judge. Just says, defendant states she takes no position on this motion and does not wish to be heard on the motion through counsel. So that saves the defense fund a couple of beans, because every court appearance is, hourly. Now, the letter that I read to you was the entire letter from Josh Levy. And he says there's a federal order in effect. You should go by the federal order. We'll see what the judge does. That may be just with respect to the stuff that the feds turned over. But she did say that she is going to release certain documents, and she told us exactly which ones. She said, I'm going to release document number 199, which was defendant's original motion to dismiss the indictment. I'm going to not release the docket number 201, which is the grand jury minutes, but I am going to release defendant's supplemental memo and support document 228, document 232, the supplemental Commonwealth's memo. And she is going to release those original police reports with identifying information of any of the parties redacted. We've been over so many motions in this case that I can't remember off the top of my head which police reports those will be, but I bet they're going to show that the original police report that was handed to defense counsel on the day of Karen's first arraignment, which I believe was February 2nd of 2022, correct me if I'm wrong, and how that was different to the second police report, which was supposed to be the same police report they turned over the first time, but there was a second report with different cell phone numbers for certain people on them and different scene photos attached. So that's going to be interesting and, in my opinion, admissible to show the 3-card Monty that's happening here. Remember how Lally referred to a 3-card Monty and accused the defense of playing 3-card Monty? Anybody know what 3-card Monty is? You ever go to a street corner in New York City and the guy's got 3 cards and one of them's the queen and he throws them around? He's like, all right, which one's the queen? And it's a quick way to lose like $50. This is what you call a 3-card Monty. When you turn over one police report on the day of the arraignment to defense counsel, and then as part of your automatic discovery, you hand over what's supposed to be the same police report, but has different cell phone numbers for some of the witnesses involved and for some of the scene photographs. So yeah, Suzanne, the conflicting reports are going to destroy the Commonwealth. In my opinion, not only the conflicting police reports, but a lot of conflicting things here. A lot of conflicting things. And it makes me wonder, makes me say, is that why none of the witness statements were recorded? Except for, guess who? Lucky's. And that was like 18 months after. 18 months after the date of death, date of the incident, we'll call it for purposes of this stream. It's the only time Lucky was interviewed by MSP. And it was only after misleading, I'll say, to be kind, the defense about who the plowing company was, who was supposed to plow Fairview that night. And they did their own due diligence and found Lucky. It was only after they found Lucky that MSP went and took Lucky's statement. And that was recorded. But most of it was about Aidan Carney, most of that interview, not about what happened on the night of John O'Keefe's death. So make of that what you will. Right, Scott? That would never fly in a real police department. This is interesting. Dawn says, I thought everything that had to do with the grand jury testimonies were private and you were not supposed to talk to anybody about what you were going to say. Yes, that is true. The Commonwealth may have been able to prep some of the witnesses before the state grand jury because they were witnesses in the case. However, the federal grand jury is a totally different issue. They are not the clients of the Commonwealth. Therefore, they should not have been having any meetings with the attorneys for the Commonwealth before testifying in front of a federal grand jury. Also, grand jury testimony is supposed to be private and not released to the public unless there's a compelling interest, as in this situation, because a lot of it has already been summarized to the public and released to the public as a result of these motions, and that was the Boston Globe argument. So she's going to release them. Hang on to your hat. Oh, Mrs. Jim Morrison, what do they mean by minutes? It means it's a transcript that comes back. So if you've ever given a deposition in any kind of case, and then there's a court reporter taking down question, answer, question, answer, question, answer, and then you get it back in book form, that is the minutes. That is the entire transcript of the testimony. So that's what that means. Everything that was said and recorded in the court record. Yay, light up that like button. Today's a day where one of those days where I just can't like think of words. So thank you, Bernie Heaven, for becoming a member. And Mark, thank you for your super sticker. Thanks, Karina, for being a member for a month. Pink, sparkly, technophobic, just like me, Melanie. Thank you. You don't know how many complaints I get in the comments that my pink sparkles are hurting people's eyes. Like, I just can't with the pink sparkles. Okay, first of all, I'm sparkly. Don't ever let anybody dull your sparkle. That's my advice for the day. Don't ever let anybody dull your sparkle. And how close are you sitting to your device? That's the other question I have. Really? The pink sparkly background is really hurting your eyes? Maybe you should move a little further away from your device. It's just my advice. Joanne, thanks for becoming a member. Thank you so much. Oh, and Suzanne, thank you for gifting 5 memberships. I appreciate you so much. You guys, this is going to get wild. Buckle up. Friday is going to be a crazy day. I'm going to be traveling, but I'm going to try. I mean, I've learned my lesson from today that live streaming the hearing for me is not a good idea. I should just do it on the replay, like later on in the day after there's good footage out there, because it makes me crazy when I can't get the good footage. So we can do that later in the day on Friday and talk about the motions in limine. That is going to be a 9 a.m. hearing this Friday, the 12th. And then jury selection is scheduled to start on Tuesday, the 16th at 9:30. So, oh, thank you, Jeffrey, who says I can't hurt anyone's eyes. Thank you. It was the pink sparkles that people are so offended by. And hey, go look at Olivia Lambo's Twitter today. She's got all the court documents from Chris Albert's fatality, car accident from, I think, 1994. In which Judge Cannoni's brother was his attorney. He served 6 months in prison, was never questioned about any alcohol use, was never tested for DUI, but he did turn himself in with his attorney something like 30 hours after that accident. Thank you, Galen, for gifting 5 attorney Melanie little memberships. That is very kind of you. YouTube distributes them randomly. I have no control over who gets them. Thank you, Jason Smith. The pink sparkly background are also not or is not a cupcake. That's right. I can't please everyone. I can't. And that's why I have a cupcake logo, because I can't make everyone happy. Just like that pink sign says over there. I can't make everyone happy. I'm not a cupcake. Like, it is what it is. You don't need to complain. Just move on if you don't like it. Like, really, I don't get it. I don't get people that really take time out of their day to just complain. I just stop. Just stop. Just go watch it somewhere else if you don't like what I have to say. I don't really care. You're not going to hurt my feelings. You're not going to hurt my feelings. Yeah, Beverly's brother. Beverly's brother was the attorney for Chris Albert. And I think it was 1994. Glare's in the house. Hi, Will. This is crazy. This is making your blood boil at all? Some people don't know this. Some people do not know this. Wait, so the brother of a Judge Cannoni was a McAlbert's lawyer? Yes. Isn't that it? Well, yes. When we went over the motion to recuse, I said, I'm surprised they didn't bring this up in the motion to recuse, but either they didn't know about it or they didn't, or maybe they're saving it. I don't know. I don't know. He's like, yeah, for real. Jack says, I don't usually like sparkles, but I like, yep, Beverly's brother. A lot of people, oh, this is so interesting that so many people don't know this. I mean, while we're here, should we just pull up Olivia's Twitter, because it's out there, but then you have to promise me, I know she would let me play it. You have to promise me that you will go follow her on Twitter because she really does have the documents. She's like me. She's fact-based. That's why I thought when I did a stream with Brandy Churchwell, it was so effective because we both have fact-based channels. So I'm going to show you the receipts as provided by Olivia or whoever dug these up originally, but it's public record, my friends. It's public record. People don't know this. They're like, oh my God, really? Like you don't know. You don't know. You don't know. All right, we're going to change to this stream. This tab, rather. As long as everyone promises me they're going to go and follow Olivia after this. And this tweet is from when? I think it was this morning, nearly 30 years ago in 1994, when Chris Albert hit and run and killed a man, injuring a second. The Massachusetts State Police recorded its interview with Chris Albert and maintained it, both audio recording and transcript of the interview. Okay. In 1994, almost 30 years ago, we had that capability. We had this little thing called a dictaphone. It was a little machine and it had these little tiny cassette tapes. And you would bring it with you to an interview and you would hit record and you would record statements because that's the way proper investigation is done. Was done then and should be done now. Nearly 30 years later, when Officer John O'Keefe was murdered, Massachusetts State Police Trooper Michael Proctor recorded none of his interviews, has 0 transcripts from his interviews, and has no notes from them either. Only exception being over a year and a half later when Lucky Loughran was interviewed. But DA Michael Morrissey's office, the Commonwealth, wants you to believe that it's totally normal. It's not normal, and the proof below will show you. And she attaches to her tweet the investigative report of Trooper William Delaney from a fatal motor vehicle accident involving Christopher Albert and the victim, the decedent in this case, Peter Berger. He hit his car from behind. The car went off the roadway, flipped over, and there was also a woman, I think, named Peggy in the car. And this is from July 10th of 1994. It's all right there for you to see on Twitter. There's a report. And here it is right here. And in paragraph number 9, on 7/3/94 at approximately 9:20 in the morning, attorney John Prescott arrived at SP Foxborough with his client, Christopher Albert. Albert was observed to have contusions on the forehead. John Prescott is the brother of Judge Beverly Cannoni. Judge's father was also named John Prescott. He was also an attorney. But this is the brother. And it's all right there in black and white, black and white. So here's Olivia. Go follow Olivia Lambo at Olivia Lambo on Twitter because she's got all the documents. And I know you guys like documents. I think it took 30 hours for him to turn himself in with his attorney. I don't know, kind of gives the appearance of a conflict to me. So Chris Patch says, Melanie, the same people who looked at the sun yesterday. I was out there. I had the glasses. Because one of my kids' science teachers bought glasses for everyone. When I went to pick them up, they were still looking at the sun, and I got to look, and I got some cool pictures of it. It was pretty cool. It was pretty cool. Yep. Emmy says, seems weird that she was a defense attorney and comes from a family of defense attorneys, but she seems so biased against the defense. Yeah. Or just in favor of the other side for personal reasons. I don't know. Somebody says it was her father, but I think it was her brother. This is what I'm going by. I mean, her brother very well could have been an attorney in 1994. Say yeah. Pretty cool. Hi, Duty Ron. How's your shoulder? How you doing? I was going to call you today. Yeah, this is the final season of Curb Your Enthusiasm. So I have still 3 episodes maybe to watch. No spoilers, please. But love that show. Love that show. Pretty cool. Suzanne said it was her brother, not her father. Her father was a very high-priced attorney as well. How does a 22-year-old kid afford that? Right. Father, brother, doesn't matter. Still a conflict, says Jennifer, and I agree. Right. The house down the Cape. Yep. All the things and all this stuff. And thank you, my friends. Thanks, moderators, for keeping it classy today. I'm going to see you again on Friday. I'm not going to stream it live because we have all the technical problems we had today and the terrible audio that we were getting from some of the RIP Curb Your Enthusiasm. So sad. From some of the stations that we tried to watch, and it was just, but we got a good lesson in body language and facial expressions because they did have better camera angles. Right? So let's do that. Everyone, please hit the like button while we're here and while we're talking about it because, helps the YouTube algorithm and all of that. And, while you're here, subscribe, like the video, hit the bell so you'll know when I go live because I don't have a set schedule. But thank you to my amazing moderators who are keeping the chat classy as always. To my channel members, my viewers, my replay viewers, I love you all so much. This is crazy. So buckle up. They're putting up the tent and the circus is about to begin. But not within 200 feet of the courthouse, my friends, not within 200 feet. Remember, as always, be cool, be kind, be classy. It is not hard, really. It is so not hard. I promise. Peace. I'll see you soon.